Now, this is the advantage of a trademark. The third statute under the intellectual property rights is called the Patents Act. Now, the Patents Act of 1970, as I said, had been amended in 1999 in the light of the TRIPS agreement, has been further amended in 2002 and then further amended in 2005. Again, to keep pace with the international agreements, and while the TRIPS agreement had given a time frame for India either to fall in the line of the international agreements or to create a statute of its own. So, Patents Act of 2005 was amended to keep the deadline which India entered into the treaty with the International Convention of TRIPS under the auspices of WTO. And therefore, there has been again a metamorphosis change into the Patents Act. Predominantly, the patents now in India are done on the basis of product, which is known as product patenting. There was another concept of process patenting. I'll explain. If you have an invention in the nature of some product and you want to get that product patented, that means if that product is manufactured, sold, transacted by any other person, that person is subjected to the royalty to be paid to the owner of the patent. But there's another concept, mostly into pharmaceutical area, that what is the process adopted to reach to that product. Because there is a lot of R&D being created, research and development, to ultimately produce that product. For example, James Watt and George Stephenson created, on the basis of water pressure, created a railway engine. Now, this was a process. Somebody else in the later years created a diesel engine. Instead of water pressure, another type of fuel was used, another process to build an engine. Engine is the product. The process of reaching to that products are different. Later in the years, somebody created electric engine, which runs on the basis of electric wires supplying the electricity. The process is different, but the product is same. That is a railway engine. So there used to be two different types of patenting. The patenting of the process or the patenting of the product. And this was mostly into pharmaceutical industry, as I said. Because the same tablet, same medicine for a disease can be created with a combination of different chemicals. So the process of creating that product is different by different companies. The research and development is different, with an idea is different. But the product is that medicine. The utility of the product is the treatment of that very disease. Now earlier, India had the process patenting. But after TRIPS, the international giants felt cheated that one can utilize the concept of the product and create it with a different process and get it patented in his name. So there was this long discussion And finally, with the amendment of 2005 Act, now India has adopted product patenting. So now if the product is patented, whichever process you use, the patent remains the owner of the product. Now, it is also to be remembered that the patents also have a time period. You cannot create a product or create an invention for time immemorial and become an owner. The registration of patent is basically an agreement between the inventor and the government. The government allows the exclusive use for exploitation of the invention for a particular period against the full disclosure of that product to the government. Now, if you see the Patents Act supported by and supplemented by patent rules, so are copyright rules, so are trademark rules, which gives the procedure as to how these patents can be registered. But when we are entering into an era of global village, with the globalization, where the products being traded internationally, we are using Chinese products, European products, American products, and so are those countries using Indian products. This exchange goes on, international trade goes on. Therefore, the need was felt that what if I registered the patent, my invention in India, and some foreign country where I supplied the product has copied it and started selling on its own. Because patent is again not only limited to time but limited to territory. Patent is always territorial. If you have registered the patent in India, its territory is India. So what about international or world patent? So mind you, there is no concept like international patent or world patent. The inventor has to register as many countries he wants to supply his product. In their respective statutes, he has to obtain patents in all the countries. There is no one unified patent for across the world. But this was also very tedious. Because if you are supplying a patented item to a particular country where also you went and got your product patented, suppose what if that country sells that product into another country where you don't have patent? So these problems keep cropping up. And these international conventions have to find solutions to these different problems, and that is why intermittently these international conventions take place and treaties are entered into. So after this whole situation where there was no concept of international or world patent, a new concept has now been created that is called PCT, Patent Cooperation Treaty, where the conventional countries who are part of this PCT, Patent Cooperation Treaty, will register the patent on the basis of its registration, its origin country. So suppose if you are an inventor of a product, got your product patented in India, you can apply to the convention countries who are party to this treaty on the basis of your registration in India with an application to register the patent in that, and there will not be much investigation because it's already patented in your original country. So the country of origination where the invention is originating, if it's registered there, PCT mandates to get it registered in different. Still we do not have one body where you patent and the whole world patent you have received. There's no such body still. So on the basis of this PCT now, at least we have reached to that situation. But does this mean that you will have to go to all the countries of the world to get your patent registered? No. Fortunately, after PCT, there are 4 ROs opened in India. ROs means receiving office. That means once you've got your patents registered in India, you can apply to an international patent into the conventional countries through a PCT RO. That is Patent Cooperation Treaty Receiving Office. In India, you can move an application to get your patent registered in all the patent conventional countries. But that is again for a limited period. So these developments are happening. As far as the registration of patents are concerned, there is also a vocation called patents agent, which specialize only in the job of getting your invention registered into patents office. And the qualification of patents agent is, he has to be a citizen of India, he must be the age of more than 21 years, he must be a graduate of science, and he must appear in a patents examination and clear that. And then he can become a patent agent. And it's a very, very lucrative profession. Because to get a patented product, an invention being patented, it's a long process. So it's not an overnight job that you went to patent office, moved an application, paid the fees, and got the patent. There's a whole process. Once you move an application, you have to supply along with an application the prescribed fee and also the specification of your product. The specification includes 3 things. First, the name or the title of the product. The second, the design of the product. And third, the usefulness of the product. In which area it is useful. What is this product? The details. That is called specifications. Now, before moving that application, or once you move that application, you have to go through the search. Earlier it used to be manual search because used to be there, the patent register. Now it is computerized search, that whether this product is already being patented or not. All this is done by the patents agent. He researches, he finds out. After he finds out that this is not being registered prior to this date, he moves that applications with the specifications. Thereafter, once you move that application, an allotment number is granted to you and being entered into data after being scanned. But the examination of your patent application does not happen for almost 18 months, 1.5 years. If you want your application to be examined early, you have to fill form 9 along with the prescribed fee for an earlier examination. Once that patent application is being examined, then it goes for publication. There's a weekly Gazette of Patents Office where all the applications are published. For 18 months, they keep it secret because your invention should not be leaked to the public without being patented. And the novelty is the only asset of any patent. So once that patent is being examined, being published, after examination, the examiner gives a report called FER. FER means First Examination Report. And suppose in the first examination report, FER, there is no objection, there is no opposition, then the patent is granted. And now, where there are objections, oppositions, pre-grant opposition, post-grant opposition, then you are entitled for a hearing. And suppose if even after hearing, you fail to convince and your patent application is rejected, there is another appellate body being created